Rashmi from greytHR and today's moderator of the session. First and foremost, a warm welcome to one and all, and thank you for joining us today in this exclusive session of Parichay-Ask the Expert. As you know, our today's discussion is on one of those important topics, EPF, that is Employee Provident Fund. Well, more than a session, I would like to say it's a masterclass to know everything about EPF, that is again the Employee Provident Fund. But before we begin, let's do a little housekeeping on how the session goes. So for first few minutes, there will be a discussion done on our today's topic with the help of our expert, which is then followed by Q&A. So if you have any questions, please type them into the question box in your Zoom control panel. I'll bring them up during the Q&A and try and get answers from our expert. Also, if you're worried about missing out on any part of our today's session due to some unavoidable reasons, not to worry at all, as the session is currently being recorded and will be shared with all of you soon. Let me give you a quick heads up on what is this greytHR Parichay all about. Well, greytHR Parichay is a series of thought leadership webinars. The aim of these webinars is to give SME and MSMEs an opportunity to connect with the industry leaders and domain experts and keep themselves abreast of the current trends and information. So in our today's Parichay, we have our expert, Mr. P. Senthil Kumar. In fact, to tell you more about Mr. Senthil, he's a regional PF office. He's from regional PF office, Bengaluru. And also Mr. Senthil Kumar is a social security administrator with interests in using digital technology and social networking tools to continuously improve the service delivery to members, employers, and pensioners. We are glad to mention here that in the year 2018, he was awarded for the second best performing regional PF office by the EPFO for the initiative to help members to retain their membership and accumulate EPF corpus and EPS pensionable service. Well, to tell you more about Mr. Senthil Kumar's journey, it all started by joining in EPFO as Assistant Commissioner in 2006 at Ambattur, Chennai. He has worked as Assistant Commissioner in Udupi Regional Office and as Regional Commissioner in Nagarkoil. He has also worked as Regional PF Commissioner in Tambaram Regional Office from 2018 to 2021. Also, to tell you about his personal interests, he is an avid reader and likes to read non-fictions, especially biographies and investment-related books. So he takes a great interest in participating in various activities related to social justice. Sir, we are honored to have you as a guest today, and we thank you for taking the time from your busy schedule to join us in this session.
Thank you.
So let me come to the topic now. As you know, today's session is all about EPF, right? So we all know EPF is nothing but Employee Provident Fund, but it is also one of the most popular and promising tools for the investment as well as for retirement planning. It is a welfare scheme brought into force to secure a better future for employees. And hence, this falls under the Employees Provident Funds and Miscellaneous Provisions Act 1952 and is applicable pan-India. So let's understand more about it through our expert today, Mr. Senthil Kumar. Sir, let us start this session with a very basic question. So from an organization's perspective, what are the critically essential documents that have to be maintained on a regular basis for the compliance of EPF?
Good evening to all. Actually, as far as the EPF Act is concerned, there is no specific records are mandated to be maintained by any company or factory as such. We rely on the records mandated by other labor laws like attendance registers, wage registers, or anything related to payments. So, but if you ask me, any documents you need to maintain, then your basic records like appointment order, then Form 11, it must be obtained from the member under the EPF and NP Act, especially under EPF scheme. So Form 11 is a self-declaration by the new joinee. Then nomination form also. So these are the declarations to be obtained and kept with the employer. Nomination should be submitted to the EPF office. That is as per the previous arrangement. That is, nomination means nomination in Form 2. Now we have a e-nomination facility. Member can file nomination directly in his portal. So records as such, EPF Act does not mandate any particular records to be maintained by the employer.
Sure, sir. And also, sir, my next question is, from the beginning of April, it is likely that Provident Fund or PF contributions of all government and private sector employees who fall under a certain bracket are going to be taxed. So we would request you to tell us the key things that one must know about the PF rule change.
Change is related to the voluntary contributions. Voluntary contributions made by the employee come member. This change is related to employees' personal voluntary contribution beyond 2.5 lakh in a financial year. So if he contributes, let us say 3 lakh rupees in a financial year, then that 50,000, that is the amount beyond the 2.5 lakhs, that will be excess contribution. That will be come under taxable component. Contributions will not be taxed. The interest earning on that particular 50,000, that will be taxed at the rate of 10% if PAN is seeded, or it is 20%, I think. So that is the main change, and a circular has since been issued by EPFO, how they are going to do that. So once interest is declared for financial year 21-22, then this deduction and all will happen. Or if a settlement happens, if a claim settlement happens for the member by crediting interest for the financial year 21-22, and if he had this voluntary contribution beyond 2.5 lakh, then any interest earned on that voluntary contribution beyond 2.5 lakh will be accounted for TDS. So that is the only thing. So procedural matter has been in detail has been dealt in that circular issued in the last month. So employers can refer that circular. Anyway, the tax deduction has to be done by the EPFO while settling a claims or while crediting the interest, or the exempted EPF trusts. So the role, the deductee must be either EPFO or EPF trusts. But employers should be aware that how it will be done, how the this new rule impacts the employees' voluntary contributions. They have no direct role in terms of deduction of this TDS.
All right. Yeah. Thank you so much for sharing the details, sir. Sir, though you just mentioned that all the details have been shared in the circular and employees can refer that. Just I would like to throw some, ask you a question in continuation with this. That is, if you could just throw some light on the steps to be taken by the employer from a compliance perspective.
The compliance perspective means, see, voluntary contributions is allowed under para 26(6) of EPF scheme and para 29 of EPF scheme. These are the provisions under the scheme which allows voluntary contributions. So para 26 talks about contributions on higher wages, that is beyond the wage ceiling. The mandated wage ceiling is now 15,000 rupees. So any employee wants to contribute beyond 15,000, then he has to file a joint declarations along with the employer. And there are three kinds of voluntary contributions. Employee can just increase the rate of contribution. Like the statutory rate is 12%. If he wants to contribute, let us say 25% of his wage, but within wage ceiling, he can declare himself that I want to contribute from this month onwards through employer to the EPF office. Here, there is no compulsion on the part of employer to match similar contributions. Employer can contribute only up to 15,000, 12% of 15,000. Okay, this particular higher rate of contribution is dealt at para 29 of EPF scheme. Para 26.6 allows higher wages. Higher wages means if a person earns basic, let us say basic 40,000 rupees, instead of 15,000, he can contribute at 40,000 rupees, 12% of 40,000 or higher percentage of 40,000 also. Here, under para 26, if employer wants to match the similar contribution, then he has to declare in that joint declaration form to be submitted to the regional PF commissioner that employer will also be contribute from this month onwards on this wages, and we declare that we will pay the administrative charges also on the higher wages. This particular joint declaration filed under para 26.6 must be approved by the regional PF office by an officer not below Assistant Provident Fund Commissioner. So this is the mandate provision in scheme. But practically, almost every employer just like that, get a option from the employee and allows higher wages contribution. But no, this is the law. Every employer is required to follow this. Okay. So this is the provision for voluntary contribution. This is the first step to be followed by the employer. Get a joint declaration, submit it to the EPF office, get an acknowledgement, and get it approved within 15 to 30 days. That is the first part. If he contributes voluntarily beyond 2.5 lakhs, then he's a member or employee should be briefed about the tax implications. That if he contributes beyond 2.5 lakhs in a financial year, then that will go into taxable part. So any earnings on that excess contributions will be taxed, so that he should be aware that. So employer can maintain a record if he wants to assist the employees. There is no mandatory directions or as such. Our employee can maintain that record, but that information or that awareness should be there on the part of employee that now from 21-22 onwards, there is no unlimited tax-free voluntary contributions.
Sure, sir. Thanks.
And one more thing, actually, para 26.6 says that if somebody joins as a first-time employee with more than 15,000 as basic plus DA and what do you call cash value of food concession, these are the things included for EPF calculation, then he is called as excluded employee. That means that person need not be enrolled mandatorily. So those persons have to join through joint declarations only. Practically, almost none of the employer is following, but that is the provision in the law. If you want to enroll a person voluntarily, if he earns more than 15,000 as a basic plus DA, then also this joint declaration form must be submitted. So if your employer start following this process, then many of the issues at the time of filing claim or transfers and all will not be there.
Sure, sir. Thank you so much for sharing the details. I'm sure all our attendees have benefited a lot from this answer. And also to continue, sir, I have a question about the PF withdrawals. So the question is, what prerequisites the employee and employer have to keep in mind when it comes to EPF withdrawal?
See, EPF as such is a old age savings scheme. Okay. And if you go to the scheme design, I always like to say, quote Mr. Warren Buffett, one of the successful, well-established investor. You save first from your earning, then take that money for any expenditure. So this scheme is designed like that. From your salary, even before payment of the monthly salary, EPF will be deducted. Okay. And this is a passive investment scheme. Once you enroll yourself into EPF, once you complete your initial formalities like submitting form self-declarations or nominations, all these things, and KYC process and all, there is no further role from member as such. So this is a passive investment scheme which has a benefit of contribution is exempted from tax. Your earnings in terms of interest is exempted from tax, and withdrawal after 5 years fully exempted from tax. So in effect, if you are paying 8.5 or 8.1, practically if somebody is in 30% tax bracket, real return will be more than 10 or 11. So that is a thing everybody should be aware of it. Sorry, I forgot your question.
It was about PF withdrawals. What are the prerequisites that you have to keep in mind?
Now you keep this in mind. Okay. When EPF is paying 8.5 or 8.1, which is the highest rate available in the market now, among the lesser risky instruments, what you call debt instruments, then your withdrawal must be you must think twice or thrice before going for withdrawal from EPF, even if it is for purchasing a land or buying a house or construction of your house, because the home loan rate, interest rate is around 6.5 to 7 only. So if you are withdrawing from EPF, which is paying very high interest rate, which is tax exempted also, if you are withdrawing money even for the purpose of such an important activity like construction or purchase, or then it I would personally say it is not advisable. For expenditures like marriage and all, definitely I would say that it is a no from withdrawal from EPF. As a advice, I would say that members are free, provisions are there. Okay, higher education, post-matriculation education, that is there. Okay, that is a much, you can say it is an investment. So that is fine. That is my advice. Otherwise, since it is freely available, we are not asking any questions. We are not asking any documents to prove that you are actually withdrawing for the particular purpose. Don't take it lightly. Because once withdrawn, we are not allowing any bulk deposit subsequently to recoup that whatever interest loss and all. It won't be allowed. Contribution is only through monthly contributions. You can make voluntary contributions, but a bulk deposit, all these things will not be allowed because there is no such provisions on this scheme. So withdrawal should be they should think twice or thrice before initiating withdrawal. Anyway, in future there will be a facility in our EPF member portal. Whenever you attempt to make a withdrawal, it will show what will be the impact of your withdrawal in your future corpus. That they are going to come up within the portal also, so that members can take an informed decision.
Sure, sir. I think that feature will be of great help to all of us.
They can very well know that what will be the impact.
Right. Yeah, which is very much required.
We should allow the what you call the compounding effect to take to work the wonders on the corpus. Right. If you say that, for an example, we have calculated, let us say your salary is fixed to 10,000, interest rate also fixed to 8.5 for 30 years or 40 years. There is no change in the salary, there is no change in the interest rate, and no change in contribution rate also. Then within 30 years, you can accumulate almost 25 lakhs. From 30th year to 40th year, that money will become 60 lakhs.
Right.
So that is the power of compounding. But if you start withdrawing, or your, whenever you move from one company to another company, you start closing your previous PF account, then this benefit will not be available. Out of that 60 lakh accumulated in 40 years, the contributions from employer and employees, it was less than 10 lakhs actually. So that, I don't think any other scheme with almost government organization or government backed protection is giving such a wonderful return without doing anything.
Right. Yeah. Sure. Thank you so much. I think the consequences that you have highlighted was much required today. So I think definitely our attendees are going to benefit out of this. I'm going to my next question, sir. It is about pension now. So can we expect the government to raise the pensionable salary limit from 15,000 rupees to 21,000 soon?
See, that is a policy decision by the government of India based on the recommendations of Central Board of Trustees. So I cannot comment. Basically, it may come, and when will it come, we don't know. That is for the government to decide after discussing with all the stakeholders like employers and employee representatives and all. But since a social security code is going to come, it is a common for all the 4 social security laws. So there is a it's natural that EPF and ESIC will have a same wage ceiling going forward.
Sure. Thank you, sir. And since we already spoke about PF pension, now I would like to bring up another related topic, which is also very important, that is EDLI, Employee Deposit Linked Insurance, right? So could you please tell us the main features of this EDLI scheme?
See, EDLI is, this scheme was launched in 1976. All the EPF members, by default, they will be members of the EDLI scheme also. There is no separate membership eligibility also. Any EPF member will automatically become EDLI member. Here, the contribution is restricted on wage ceiling only. Contribution is, we can call premium, is from employer side only. There is no contribution from employee or member. So that is the design. And the maximum benefit available now from last year onwards is 7 lakh rupees. Just 10 or 12 years back, it was just 36,000 or 60,000 only. Now it is more than 12 times it has been increased. So now it is 7 lakh rupees. The benefit, the only one benefit is available under this scheme. Someone, an employee member dies during his employment, then his nominees or legal heirs will be paid this benefit under the EDLI. Maximum is 7 lakh. Not everybody will get the 7 lakh. There is a criteria or formula there in the scheme. Based on that, the amount will be arrived and it will be paid to the nominee or family members.
Sure.
But the important condition is that someone, if member dies during his employment.
Okay. All right. Thank you so much, sir. Sir, I think now we will move to our attendees' questions. I can see that we are flooded with questions already. So dear attendees, I'm going to take up all your questions one by one. So here the first question I could see is one of our attendees have this question, sir. And the question is, can employer collect the soft copy of Form 11 and Form 2?
See, Form 2, EPFO itself has given the alternative, that is e-nomination. Okay. So if a member filed his e-nomination and signed it through e-sign, that is Aadhaar-based OTP, then get that printout. That is enough. Okay. There is no question of getting a Form 2 in soft copy. Fine. And as far as Form 11 is concerned, we need a signed declaration from the member. It's very important. So if he digitally signs, okay, because now we are accepting the employer's digital signature also, digitally signed documents can be accepted. But somebody signs and scans that and upload it in a portal or submits through email and all, that cannot be relied upon. So it's always better to take a declarations personally in paper or obtained a declaration in digitally signed form using digital signature as.
All right. Hope that answers the question. And there's another question from the attendee related to Form 11, sir. The question is, can Form 11 be taken from employee or potential employee, even if he or she has UAN?
See, UAN is a different thing. Form 11 is a different thing. UAN is it is an identification ID number for a PF member. Okay. So once UAN is created, it won't go away. It will still remain in our records, even if a member dies. But Form 11 is a mandatory declaration to be obtained from each and every employee at the time of joining as per the scheme. That is a legal mandate. Let me say, if somebody has a UAN, he worked in, let us say, 1 or 2 years back, he closed all his accounts and all his PF accounts under that UAN. So now this Form 11 only will give you clarity whether he can be mandatorily enrolled or he is excluded employee. If company decides to enroll him, he should be enrolled voluntarily. In that case, voluntary members will not get EPS. So all these things will be decided based on Form 11 only. So Form 11, there is no question of there is no option here. It is a mandatory declaration.
All right. Sir, our next attendee has a question on how to change the father name in the records.
It's a very, very current topic, I would say.
Yes.
Because we are flooded with such requests. Because many employers have done very casual mistake of entering father name, anything, any characters they have entered as a father name. Without realizing that submitting details, member details in portal, in employer portal also, you are actually doing a statutory act. That is as good as the old Form 5. But unfortunately, many have done this casual act. But how to correct? Let us understand one thing. Once your data is entered and approved by employer in his portal, that becomes a permanent data. Once data become permanent, then change can only be done by the concerned EPF office. Anything, whether it is a member-related data, many details are there: name, gender, date of birth, father name, relationship, spouse name, relationship, date of joining, date of leaving, contribution details. Anything related to member, once entered by or declared by the employer and approved it cannot be modified by the employer. It has to be modified, changed by the EPF office after receiving a due request through joint request or joint declaration form with sufficient attachments. It varies from case to case based on the request made. So father name, and as far as Bengaluru Central is concerned, father name change. Change means here it is not a simple change like expansion of a name or you are changing the initial from front to back, not like that. If the existing father name is wrong, it is not related to your father, then it is called a complete father name change. Complete father name change, we will be asking basic records like appointment order, first joining month wage details, and a credit proof for that. Then a separate declaration from the employer that the particular PF account belongs to the claimant and the contributions remitted to that particular EPF account belongs to the member. Employer has to make a specific declaration. And this father name change, as far as Bengaluru Central is concerned, can be done only through first PF office. First PF office means through first employer who generated this UAN. Okay. Subsequently, after generation of this UAN by one employer, member might have moved to second or third or fourth, and the error may be, the wrong data may be same. The second, third, or fourth employer also would have continued with the same wrong father name. We will not accept the request from second or third or fourth employer. It has to be done through the first employer, because what kind of mistake he has committed, he only knows. Whether father name is wrong or member name itself is wrong, whether this UAN and PFID belongs to the member, only first employer can certify it. That is the reason we are asking that. This is how it can be done, through joint declaration form with certain records and specific declarations from the employer only. Father name, that is a wrong father name, can be changed. The small minor changes and all, any employer can request with the Aadhaar, PAN, wherever father name is clearly available. It is my advice that kindly check your active member details, download your active member details, and check each and every member's father name. Whether some of the father names are X, Y, Z, all these are null, not available, all kind of data have been entered by employers. So those cases you identify, initiate the process for change. Otherwise, even if it is Aadhaar is verified for those UANs, a member, if he files a claim, it will get rejected.
Sure, sir. Thank you so much for giving us this wonderful piece of advice, because I think not just one or two attendees today, most of us are facing this issue today. So I think your answer helps us a lot in this aspect. So I'll move on to our next question, sir. It is related to our post-COVID situation. So our attendee has this question, that is, post-COVID, many candidates or employees are asking net take-home salary without contribution to the PF. Is that recommended?
So as I said to the question related to withdrawal, see, everybody needs old age social security. That is the reason, even though wage ceiling is provided for mandatory enrollment, still EPF scheme allows voluntary enrollment without regard to the wages earned by the member. So why it was introduced in 1952 itself? At that time, lawmakers, parliament thinks that when it is, it is left to the employees to save on their own for their old age protection, 90% of the people may not save. Those who are saving also, over a period of time, they may reduce it, that they may stop it also. That is the reason this mandatory saving scheme is available. This is for somebody who earns up to 15,000. Okay. For anybody, for any employee who is earning through wages, definitely some kind of savings should be there for his old age. So when voluntary enrollment is allowed, employees should be advised why he is asking for not to enroll to EPF. Just increase take home salary, then that is a clear case that he needs a EPF. Reason is that if he wants full salary, then it means that he wants to spend in the same month. Definitely there won't be anything for his saving. Then who will protect after 60 years?
Right. So I think it is a very thought-provoking question that we have put now. Thank you so much, sir. I'll move on to our next question. So our next question is about linking the Aadhaar. Okay. So the question is, if the employee missed to link their Aadhaar in UN, can employer do this from employer portal?
See, UAN Aadhaar linking. The only three basic details we are verifying for this UAN Aadhaar linking. That is name, gender, date of birth. These three details must be exactly matching when you compare UAN and Aadhaar. Identical match should be there. Okay, date of birth, gender, it is a simple, not an issue, but name should be identically matched. No space, dot, nothing should be there. Okay. Then in that case, if every detail is same, then employer member can initiate that KYC request and employer approve in his login through digital signature. That is, verification is over. Otherwise, member has to give some change request also. Change request along with Aadhaar seeding. That is called basic details change request. It is there for last 4 or 5 years now. So that has to be initiated and you will come to employer, then employer verifies and forward it to EPF office. EPF officers, after verification, they will approve. This is UN KYC. But I think somewhere in the last 2021 end, process has been changed. Reason that if UN and Aadhaar is not verified for a member, he cannot log into his portal. So now there is almost less than 5% possibility that if UN is not linked with Aadhaar, he can give an online request. Not a possibility. He has to submit a joint declaration form through his employer to the concerned PF office for changes as in Aadhaar, then Aadhaar seeding. It is a simultaneous process in EPF office. Once the changes are accepted, Aadhaar is seeded, then he can reset the password or activate the UAN, log into the portal. He can do all other KYC things.
Sure. I'll move on to the next question, sir. So
one more question, I think they are raised related to father name change. Someone raised that, first employer is first establishment is already closed, then who will certify the request and all? So we have an alternative. Then in that case, it is the responsibility of the individual member to prove that he worked in that particular establishment from that particular date of joining, and he has to provide appointment order copies, salary credit, any other employment related document to cross verify that this PF account belongs to him. Okay.
Sure. Yeah, I hope the question is answered. Thank you so much, sir. And sir, we quite often...
In that case, even a current employer can make a request, but a member has to give these records from his own. Okay, responsibility lies with that member only.
Sure. Yeah. Sir, we usually talk about the full-time employees when it comes to PF, like we only consider them. But many of our attendees are also very curious to know how is it applicable to the part-time employees? Like as in what is the applicability of PF contribution for part-time employees?
See, as far as EPF Act is concerned, these words, part-time, temporary, casual, all these things are not there. It is simply employment. A person is employed in or in connection with the work of the establishment and earns wages. Then, if that establishment is under EPF, and if he has a salary within 15,000 or less, then he has to be enrolled, even if he works only for a few days. This question, why we employers side repeatedly raising, I don't really know, because there is no such word in the EPF Act is concerned. Purely casual or incidental only, after proper examinations, will be allowed for exclusion. Okay, like you have a rain all of a sudden rainwater entered in your premises, you employ a person to just pump out the water. Okay, that is purely not related to your establishment, regular work. You can say that it is a casual. But anything related to your establishment, regular work, even it is a housekeeping or security, or if you are running a canteen, then every employee is your employee, then he has to be covered. He satisfies the conditions, other conditions.
Sure. Thanks for the clarifications. I think that rules out many of our questions about the different types of employment, what we have when it comes to PF. So I'll move on.
EPF Act doesn't differentiate any kind of employment. Only in terms of benefits, I think it has dealt related to seasonal employment and all. It is related to only how to calculate the benefits or arrive the wages for pension and all. Not related to enrollment at all.
All right. So I think that simplifies a lot of things for us. All right. So we'll move on to the next question, sir. One of our attendees says UN basic details and the other name is mismatched. So in this case, what do we do? Can I submit joint declaration to nearby PF office? Because employee is in Bangalore, but registered PF office is in Maharashtra. Please suggest.
See, it's like a bank only. Your service provider is your respective concerned EPF office. Okay, banks might have moved to centralized core banking system where there is certain facilities available in the online net banking. But as far as EPF is concerned, even though your UN is portable, please understand, UN is portable. But PF account where all the transactions are recorded, UN is different, PF member ID, as we say, that is the old PF account starts with the BGBNG, MHBAN. That is the real PF account where all the transactions are happening. Those accounts are in the custody of respective PF office only. They only know the full information related to that PF account. So you can submit, ideally, you know, any PF office will accept your joint declaration form, but it will be sent to the concerned PF office only. They can only take action on that particular PF office.
Sure. Thanks for the answers. So hope that clarifies the doubt one of our attendees have. So next question is a bit elaborated one because
here actually, before going to that, I want to elaborate.
Sure.
Members and even employers have this misconception that the UN is portable. I have a UN. So they start forgetting about what is PF member ID at all. PF member ID is the most crucial thing under that UN. UN is a thing, it identifies you. It does all the KYC things. But all the PF contribution credit, withdrawal, interest credit, any other transfer credit, everything happens in PF member ID. And if you move from one establishment to another establishment, there is no automatic transfer. Okay, we have a facility to trigger automatic transfer claim, but that is under certain conditions only. Otherwise, members should ensure that whenever he moves from one establishment to another establishment, his previous PF account is closed and transferred to his present. Just because under one UN he has all the PF account doesn't mean that from the latest PF account he can withdraw all his previous PF account. No, it has to be transferred to the latest, then only he can withdraw.
Sure.
It is his responsibility, member's responsibility, to ensure that it has been transferred.
All right. Sure, sir. So I'll move on to the next question, sir. As I was telling you, it's a bit elaborated question because here the attendee is seeking for the answer under different scenarios. So the question is, what will be the PF compliance requirement in the following scenarios? So the first scenario is, for a construction project, the principal employer who is covered under PF has engaged multiple independent contractors for various works. So if any of the contractors do not have a PF code citing less than 20 employees, should the principal employer insist on such contractor to obtain a voluntary coverage? What if the contractor is not willing to register himself if the activity is for just 10 to 30 days?
Okay, let me answer that.
Sure.
Here, simply, if a principal employer is already EPF registered establishment, any contractor he engages even if that contractor has only one employee, that employee must be covered under EPF. Okay. And if contractor refuses to get his code number, no, we have no issue with the contractor. But responsibility lies with the principal employer. He has to enroll under his own code. Okay. Otherwise, it is between the contractor and the principal employer to have an agreement that any contractor he takes for any work, it is a mandatory to for them to register with EPF. Registering a contractor is administrative convenience only. Final responsibility always lies with the principal employer. If the work is executed for him in his premises or in his project sites, whether that work is for 5 days or 10 days or 20 days or 30 days. There is no separate counting of the number of employees in the contractors. That is irrelevant, immaterial here.
All right. Sure, sir.
Similarly, other way around also, let us say principal employer has only 5 employees. He has not registered with EPF since the employee strength is 20, less than 20. But he engages a contractor, through him 20, let us say 15 employees are engaged, then both should be covered. Now the strength reaches 20, including direct as well as indirect employees. So both principal employer and now contractor has to be covered. So for any such situation, you should always present the facts to your regional PF office, get in writing whether law is applicable or not. Don't assume whenever these kind of situation arises. Don't rely on some third-party advices, oral advices. It is very seriously damaging. It will tomorrow end up in a huge financial liability for the concerned organizations.
Right. Yeah. Thank you so much, sir. Sir, the next question is about having multiple accounts and the transfer of PF. So the question is, one of the candidate has 2 UN accounts and has transferred the PF to one account. Now the amount is transferred, but the tenure doesn't get transferred. The concern is this. So when will this get sorted?
So I should admit that there is a lack of transparency in terms of surveys, pension, all these things from EPFO side. Anyway, that is going to get sorted out in maybe in another 45 days or 60 days. Members will be able to see their service transfers, pension related transfers, credit, everything, even calculators also in another 2 months. All related relevant information will be available either in member portal or pensioners portal, wherever it may be. This transfer, let us say that member worked in one establishment where company remitted the both PF and pension to respective RPFC. Now he has moved to another establishment. He got the transfer done. This EPF passbook basically designed to show only EPF part. Okay, since EPF has 3 schemes, EPF, ADLI, pension, that is EPS, this passbook shows only one particular part, that is EPF. What is your contribution, employee's contribution, what is employer contribution? Then pension contribution. Pension contribution is shown only for the information purpose. Otherwise, this passbook is only for EPF. Okay, so when a transfer is done from one account to another account, there are 3 transfers happens. EPF amount, EPF service, as you said, tenure, then pension service also. There is no transfer of amount from one PF, one pension account to another pension account. There is no such transfer. We are transferring only the service, pensionable service, his last 12 months wage details, or any loss of pay, that is a non-contributory period. These are the important details which are transferred from one pension account to another account. So this transfer will not reflect anywhere in your portal. Because the design is not like that, they are not showing it. It will come in another 2 months. As of now, it is not shown. So when a transfer happens from one PF office to another PF office, when amount is transferred and credited to new account, you can very well assume that your EPF tenure or service as well as pension service also have been transferred and credited. If you want a confirmation, ask for a member ledger copy from the present PF office. It will show all the details, service transfer, credit, everything it will be shown. You can get a member ledger copy from your present PF office through your employer. And even though previous EPS account was closed, you will not see any closure or any withdrawal from the passbook. Reason is that the pension contribution is displayed for you only for information purpose. That contribution is received.
Sure, sir. Yeah, I think all of us will be waiting for this great thing that is going to happen in another 60 days. Thank you so much for giving us update on that. So I'll go to the next question, sir. It is again, how is the PF compliance applicable if the principal employer has less than 20 employees and is not covered under PF, but has engaged multiple independent contractors who are registered under PF? So then does the principal employer still need to obtain a PF registration and file nil returns?
Yes, as I said that if a total strength reaches 20, then principal employer has to cover that the total strength includes the employees engaged through contractors also.
All right. Thanks for the clarification, sir. I hope that answers the question.
In that case, let me clear with that.
Sure.
When you reach 20 employees and your business activities under scheduled business activity as far as the EPF Act is concerned, then the Act is applicable on you. Then you have to register with the EPF, get a code number. That is one part. Now you have to go to the scheme compliance. That is whether eligible employees are there in your organization to enroll under EPF. If nobody is there, or employees are there who are earning higher wages beyond 15,000, then you can simply file there is no nil return as such. You can simply remit minimum administrative charges, send a communication to the EPF office at the start of the compliance that we have either we have no employees or we have employees all are earning more than 15,000 and they are not eligible for mandatory EPF.
All right. Thank you for the clarification, sir. Sir, since we are already talking about PF compliance under different scenarios, one of our attendees has this interesting question. How is the same PF compliance applicable for the international workers?
The international workers, the scheme special provision is there. You can refer that. There in terms of enrollment or in terms of contribution, there is no wage ceiling for international workers. That means anybody, any foreign national holding foreign passport comes to your establishment, works for you and earns wages from your Indian book of accounts, then he has to be enrolled as an international worker and he has to be contributed without any wage ceiling. Okay. And here that even though there is no wage ceiling, but his contribution should be on applicable components. Okay. Like, for simplicity, HRA is excluded from EPF. So if international worker is being paid as a HRA, then that particular component need not be included for EPF calculation. Or similarly, any production related bonus, incentives, all those things are always excluded. Okay. Only wage ceiling is not applicable to international worker.
Sure. Thank you so much, sir. Another important and the common question we have got from our attendee, at times name in Aadhaar and UAN are mismatching, hence KYC is not verified. Please suggest a solution.
Solution is always the same. Either you change the details, especially name in Aadhaar, or change in EPF. If online portal is accessible to you, you make a request through online. Or if it is not possible, make submission through joint declaration form. This is the only solution. And whenever, see, verification is a dynamic process, please understand. Let us say that a member A has completed the verification last month. Now he goes to change his name in his Aadhaar. That means next time when you try to file a claim or something or e-nomination or something, verification will fail because now the details are not matching. And he has to give once again the request for change. I would accept, since already verification was completed, the second subsequent changes and all, I would accept directly from member. There is no need for any joint request. But no, you cannot use this as a solution for all offices. Many of the offices for any subsequent corrections also may insist for joint request. But corrections, details in UAN and Aadhaar must be all the time matching. Otherwise, member cannot perform any serious activity in his portal, like e-nomination, KYC addition, claim filing. He can't do anything. So that he must be aware. He can't just like that play with the names in Aadhaar or something else.
Sure. I hope that answers the question. Thank you so much, sir. So next question is, one of our attendees very much interested to know about the scheme called ABRY scheme. So the question is, what is ABRY scheme and any chances to extend the last date?
The last date is already over. Scheme is no more. Scheme is allowed only for those who already registered. Okay. So any chance of extending it is within the domain of Government of India, because it was the Government of India which was paying these contributions. The ABRY scheme is basically to reduce the burden of the employers during this COVID time, because they have difficulty in running in business in full. So there are many difficulties. That's why this scheme was introduced. Since we have come back almost normal, so that scheme has been discontinued. If government wants to revive or extend it for a further period, it is government only has to decide. Under that scheme, anyway, since no new registrations or enrollment is allowed, there is no meaning in discussing about that scheme now. Those who have already registered know the scheme. Scheme details are available on our website with FAQ and everything.
Okay. Yeah. So I hope that answers the question. And also the attendees, due to lack of time, I'll be taking up one last question for the day. And also, if any of your questions are unanswered, please don't be disappointed. I have a solution for you, which will be told to you in just few more minutes. All right.
No,
so
if possible, we can extend to 15 minutes or half an hour. I can answer, not an issue.
Sure, sir. All right then. So the next question is about PF refund issue, sir. So I have PF refund issue which is not getting closed, and department is dragging it since more than 5 months. So can you please suggest how it can get solved? Escalation options, if any, to get the issue resolved immediately.
Actually, I don't understand the question. PF refund means, is it a excess paid by the employer and he is asking refund, or member filed for withdrawal and he is not getting withdrawal?
I think we don't have a clarity on that, sir.
Then let me assume that it is an employer who made an excess payment. He wants a refund. Then he has to prove that it is an excess payment to the concerned regional commissioner through written request with all records required by the regional commissioner. Once they satisfy, I think they will refund. If it is dragging for months, then employer also can file a grievance under EPF IGMS. That portal, grievance portal, is available for member, employer, pensioner, and there is other category also. If somebody is not covered under EPF wrongly by his organization, he can complain. So all can file grievances. Any grievances has to be resolved within 7 to 15 days.
Sure. All right. So the next question is, sir, how should we calculate the PF wages? Is it basic plus DA or basic plus all allowances except HRA? There's a confusion on this.
See, confusion has been set right by the repeated Supreme Court judgments. As late as February 2019, also there is a judgment reiterating the old judgment. Okay, so that is very clear that all the components of the salary which is paid regularly, normally, and universally. I think they have used the three words: regularly, normally paid, must be part of the basic wages. Something which is incidental to particular action, let us say leave encashment, it will not be part of your EPF calculation. Or a production incentive. Production incentive cannot be claimed by each and every person on the same line, or it cannot be fixed in advance. It is based on his actual contribution in a particular month. Only those kind of things can be excluded. If you are naming a particular component of wages, special this and that, but regularly paying from the day one, that is part of your agreement itself, then I would say it is a part of your EPF wages, basic wages.
All right.
So advice would be, if you have a particular structure, you have any queries in a particular component, then discuss with your concerned regional commissioner, or refer with your area enforcement officer. Make an official request.
Sure. Sir, from the same attendee, we have one more question. I think this is pretty much clear, but still I would like to get the clarification from you. So the question is, if a company has less than 20 employees and are willing to enroll with voluntarily EPFO, the contribution will be 10% or 12%?
Somebody who comes voluntarily under EPF and he has less than 20 employees, that employer and the majority of employees, while making that agreement for EPF registration, submitting an agreement between employer and majority of employees is compulsory for voluntary coverage. They can decide either 10 or 12%. They can choose the percentage. But once that employment reaches 20 on any particular day, then automatically 12% will be applicable. Thereafter, only 12% has to be paid. Till that time, employer can choose even 10% also.
All right.
But it should be part of his application to the concerned regional commissioner.
Sure. Yeah. Thank you so much for the clarification, sir. Sir, we were talking about nil returns in one of our questions. So our attendee has asked this question: what will be the nil return amount? Is it 100 or 75?
Sorry, it is, I think.
Yeah, I'll repeat the question, sir. It is about nil return amount. So,
yeah, and I understand once the establishment has no employees, it has to remit minimum administrative charges. I forgot that amount, whether it is 75 or 100, like that. Okay. Only in administrative charges, that is account number 2, the employer has to make that minimum charges. I think originally it was 100, because in account number 22 also he has to pay. Now there is no account number 22. That is, there is no EDLA administrative charges. So I think it is 75 rupees is enough.
Right. Yeah.
You can check the scheme provisions in the website. Okay. These are all facts. Okay.
Sure, sir. Thank you so much. Yeah. And next question, again, it's a very common question, but I think it's very important for all of us to know about this. So can a standard 1,800 be deducted from all employees? How does this work?
See, I have discussed that voluntary contributions. See, don't fix this amount, this 1,800. Many people are thinking that this is the EPF compliance. You have to start from wages. Okay. Whether a person joins with less than 15,000 or less, then he is a compulsory member. Then based on his wages only, the contributions will be. Let us say he earns 18,000 as a gross wages, 4,000 is HRA, then 14,000 is EPF wages. Then there is no question of 1,800 for him. But let us say for all the employees in a particular establishment earns more than 15,000, all have been voluntarily enrolled in the EPF, then all their contributions, minimum contributions will be 1,800 in EPF. Then similarly in from employer side also. Okay. So you need to check with the wages. You can't fix an amount. There is no straight away, there is no contribution amount here. There is a wages, then there is a rate of contribution. This is how you can calculate. So those who are joining with more than 15,000 as basic wages plus DA, all these things, must be submitting a joint declaration form to enroll themselves as EPF member. And these voluntary members will not get pension membership. All 24%, 12 plus 12 will go to the EPF only. This is one of the biggest issue for the last 7-8 years. Many employers have committed mistake. Many members without the awareness, they have made a mistake also. So please be very clear about that.
Sure. Sir, I'll just take one last question for the day. It is regarding exit date of the employee. So the question is, does employer have a right to give the exit date?
Right to
hold the exit date of the employee.
See, exit date is when somebody exited from the employment. If it is he has legally exited, like he has given a notice, tendered his resignation, or he has retired. Although there are many reasons for exit, but somebody is who absconds without any information to the employer, then employer has to follow the law, legal process, issuing notices and all these things. But if there is no legal dispute in a court or something, then there should be a date of exit after following all this process. Okay, he cannot hold. See, don't think that to prevent a member from withdrawing EPF, employer can hold updating this date of exit. That is not acceptable. Nobody can prevent a member legally withdraw his EPF if he is entitled for it.
Sure. Yeah, I hope that answers the question.
If the exit is under a legal question, employer has sent him out, he is disputing, dispute is in a court, then he can't put an exit. Otherwise also, without employer's knowledge, if the employee updated date of exit, employer can very well question it by raising a dispute with the concerned regional governments.
All right. Yeah. So thanks for the elaborative answer, sir. So I think, dear attendees, it's now time to wind up this session. But before that, in case any of your questions are unanswered, please don't be disappointed. You can always reach out to us on our community platform, greytHR, or you can write back to us on the mail ID sharmishta@greytip.com. And to tell you more about our greytHR community, it is basically the Q&A forum where a lot of knowledge sharing happens through many of the HR peers and also industry experts, just like Mr. Senthil Kumar, who also has the expert panel. Like we have around 10 plus industry experts as the expert panel on our greytHR community. So if you have any questions, please feel free to post it there, and I'm assuring you, you'll definitely get the answers over there. All right. So I think on this note,
so one final thing, madam.
Yes, sir. Please. Yeah.
I have not touched, during my discussion.
Mm-hmm.
Please, understand that filing a nomination is a compulsory thing. Para 33 of EPF, it made it very clear that at the time of joining itself, like Form 11, you have to submit a Form 2 to the employer so that employer can fill his part and submit to the commissioner. So that is a compulsory activity. Okay. So now the alternative is e-nomination. So don't ask that whether e-nomination is compulsory or not. What is the notification? Notification is para 33 of EPF scheme. Okay. And don't rely on the message coming in the portal that e-nomination is not compulsory for claiming advance. Please read it full. Okay. I would say that since nomination is compulsory at the time of joining itself, there is no question of any service to the member without nomination. So all of you are requested to ensure that you file your nominations and ensure all your employees are also filing nomination. get a copy of their nomination also and keep it as your record. And then ensure that for all the new joinees, this process is done at the, what do you call, at the onboarding itself. Okay, as part of your onboarding process.
Sure, sir. Thank you so much for sharing this information with all of us. And also, dear attendees, I can see many of you are asking the email IDs. So here is the mail ID as you can see on the screen. It is sharmishta@greytHR.com. You can always share your questions here and we will respond to your questions at the earliest possible. And also, I think it's now time to conclude the session. But before that, I thank our honorable guest, Mr. Senthil Kumar, for helping us gain insights on EPF, and also thanks to our attendees in making this session successful. I hope you found this session helpful and informative, and we'll be looking forward to see you in our upcoming sessions. Till then, stay safe, take care, and have a great time.
Thank you.
Thank you, sir.